Hey guys, so in this particular lecture, we are going to start discussing question 7 of IPR and Cyber Law paper solution 2016. As you can see, in previous lecture, we are already done discussing question 6 and all its sub-question. In this particular lecture, we'll start discussing about what are the basic principles of patent law and how we can acquire patent. What do you mean by patent? Few of the things we are going to discuss here. Now let's start discussing the same. As you can see, I have provided broad points here. Principles of patent law. Now before discussing this, let's discuss what do you mean by a patent. Patent means some innovative idea. If I have invented something which is very useful in any XYZ field, it might be in chemistry, physics, biology, it might be in computers field, electronic field, mechanical field. There are so many fields, more than 30 fields present in which we can acquire a patent. Now, if I've invented some idea and if I don't want some other person to misuse the same, then I can register that particular idea on my name. Remember, but there are some eligibility criteria also present there. So if I want to acquire a patent on my idea, then that patent should be novel or new. Remember, this is the most important part. It should be novel. It should not happen that just by copying some another person's idea, I've just made some changes in that existing idea, and now I'm trying to register that particular idea on my name. That considered to be infringement, that considered to be a crime, that considered to be a piracy. So every invention must be novel. It should be different from existing inventions that have already been known in a particular field. This is the most important part. One more point which we can use here, and that point is I can extend some idea. Remember, I can extend some idea. For example, there are some law which is already derived by Einstein or Newton, but now I'm working something. I've invented something new using the same law. I've extended it, and that is what we mean by extension of an idea. And for those type of invention, there are also category of one patent is available, which is called as petty patent. Remember, petty patent. If some idea is already there in a public domain, but I'm inventing something new, then that idea is called as petty patent. For example, in beginning we only knows about computers. Suppose there are no laptop or tablet available in today's time. There are only computers, and if someone invents a laptop which is not known in public domain yet, it is computer only, but from our huge bulky computers, someone created one portable device that is also kind of a computer, and that is an extension of existing idea. And for those type of invention, we provide PT patent, that is extension of existing idea. That is not something totally unique, but some part of that idea is unique. If an invention has a prior publication and prior use of an identical invention, then it is not novel for the purpose of patent. I hope this particular point is clear. Now let's discuss the second point. As you can see, the invention should involve inventive steps. That is, it should be non-obvious. Every invention should be non-obvious, especially in field of art. This invention should be continuous so that new invention or new features can be added to that particular invention. One of the most important point, as we know, iPhone is a patent for their devices. Now, if they stop making any other changes in existing iPhone, then their patent might expire in few time and some other person can acquire the same. So if I want to keep that idea with me, then after every certain time period, I have to show changes in that existing idea. I have to show that I'm working on the same idea to make it much better. Hence, due to invention which has inventive steps helps to improve a skilled person in a particular field. Let's discuss the third point. It must be capable of industrial application. This is the most important part. I've invented something, but that invention is not helpful in public domain. That invention might harm environment, that invention might harm public health, or that invention might harm in some that might harm in any different way our society or animals or any xyz way. Then those inventions should not be comes under a category of patent. Remember, only those inventions which are new, non-obvious, which are not known to anybody till now, plus if they are industrial specific, they are useful or helpful anyway in our public domain, then only those idea considered to be a patent category idea, or those idea are eligible for patent. Every invention made should not only be a new and non-obvious, but should be very useful. This is the most important part. If invention is not useful, then it cannot be patented. This is the again most important point. Thus, invention should be involved technical knowledge and economic significance. If you have invented some idea, but uh, that idea kind of which we cannot use anywhere, then what is the use of providing it a patent? Patent means government provides you an assurance that your idea no one can use it without your permission, and if someone tries to use the same idea, then you can just go and file complaint in patent office, and they can uh, those patent office, or uh, we can say a body which sits there to handle this type of a dispute, that body is going to uh, investigate on the same case, and then they have that authority to punish the criminal as well. So government provides you so many benefits under this type of a registration. So in return, if it provides something to government, then only government provides you this type of a benefit. If your idea is unique, it is non-obvious, but it that idea is not at all in a kind which we can use in public domain, then that idea should not be patented. That is the only reason, because government provides you so many securities, so many benefits, and in return government should also get something in return. Now, invention should fall within the provisions of Section 3 and 4 of Patent Act 1970. So, what are the provisions? Every act has certain provisions, as we know. If an invention fall under Section 3 and 4 of Patent Act, then only then that invention cannot be patented. Thus, no invention should fall under any category of subject matter, especially under provisions of Section 3 and 4, which excludes in Patent Act 1970. As I said, if your invention is something new, non-obvious, but it might harm environment, it might harm animals, it might harm public health, then that should not be patented. That falls under Section 3 and 4. I hope this particular question is clear. There is also one more part of the same question. There are some exceptions to the principle of criteria of Patent Act 1970. What are the exceptions? Invention made in the field of medicines. Now, there are some invention made, but government plans not to provide patent on such ideas. For example, polio dose. If government provides patent on that particular medicine, then some company might get royalty of the same product or same medicine, and as a result government cannot provide the same medicine free of cost in a public welfare. So if we talk about some cancer medicine which can save thousands and thousands of life, and if if government provides patent on that particular type of a medicine, that means some company got the authority, total authority of that medicine, and hence we cannot provide it free of cost, or we cannot distribute it in a public domain without the consent or without the permission of that company. And hence, if we want to save many people, then we follow one policy where we do not provide patent to medicines. Remember, we do not provide patent. In most of case, we do not provide it. The only reason is, if we provide a patent, then that company is the only sole authority of that particular type of a medicine, and that company starts charging royalty on the same medicine. And hence a result, if you see some private company is selling some cancer medicine for 50,000, including royalty and all their expenses which they have invented during the phase of research and development. And the same medicine, if government provides, people can buy the same medicine for the cost of 4 to 5,000 or 10,000 maximum. So you can just see the difference. And if most of you follow the news, our Prime Minister Narendra Modi also taking the steps in the same direction. So as you can see, there are some exception in patent. Why we do not provide patent on such product which are very helpful in public domain? This is the only reason. If we provide a patent, then that becomes the sole authority of some company, and that company can offer, or that company can starts earning huge profit. And only a person who has enough money to purchase those medicines, they can only save their lives. But what about our poor people? And hence, do not provide patent on medicines. Invention made in the field of agriculture and horticulture, those type of inventions are also not comes under patent. Why? Because as we know, in India, farmers way of living life, or we can say condition of farmer, is very poor. If some scientist invented something which might help farmer to produce more food, then if that idea is patented, then our farmer cannot use it easily, and we cannot help our farmer to grow better. Same way, if invention made in the process of treatment for plant and animals, this type of inventions are also not comes under the purview of patent. Invention made in the process of medical or surgical treatment of animal, and the same way invention related to atomic energy. This is the most important part. We cannot directly provide patent to a person who invented a new nuclear bomb. Remember, rights of such type of idea remains with government only, and in government also with some specific atomic department only. So we cannot provide this type of patent to any XYZ company. This is the most important part. I hope it is clear what do you mean by patent and what are the exceptions, under which ideas are not patentable, which ideas are patentable. I hope this particular point is clear. Let's discuss next part. This question is also based on our previous topic only. As you can see, explain trade related aspects of intellectual property rights. Remember TRIPS agreement, which is under WTO. Remember World Trade Organization. Under World Trade Organization, we have signed many agreements in the year 1995. And out of those many agreements, one agreement is TRIPS. So it basically deals with, or it basically look after intellectual properties at international level. So all the countries should follow one standard rules or protocols with respect to intellectual property. This is the main aim of TRIPS agreement. So let's just discuss. Now remember, India signed WTO, under which we have also signed TRIPS agreement. So WTO or TRIPS, we can say India signed in the year 1995, and after 10 years, those agreements are officially applied on India. Remember, India basically got time of 10 years to apply all those rules and regulation in our country from international bodies. So in the year 1995 we signed it, and from 1st January 2005 all those rules or agreements applied or applicable in India. So as you can see, in 2005, in order to comply with the requirement of TRIPS, the Indian government introduced product patent on pharmaceuticals. For previous 3 decades, such patent has been forbidden. Why? Because we face many problems. Many people died. Why? Because we have provided patent to many pharmaceutical companies who basically invented medicines for cancers or medicines for HIV/AIDS. And if we are providing patent over this type of medicines, and hence a result, this medicines not coming under the reach of poor people. And if we want to save our poor people as well, then the only way left is do not provide patent over such type of inventions. So let's discuss the same thing. As you can see, I have provided one points here, few of the points. Need of TRIPS agreement in India. So let's discuss points here one by one. So first is pharmaceutical company were first introduced in India by British. So this is many very basic point. But in Patent Act 1970 changed the course of prohibiting product in patent on medicines. So after we amended, or once we have created Patent Act in the year 1970, we have changed terms and condition where we are only going to provide patent to some specific parties only, and medicines company or on medicines we are not going to provide patent at all. Main topic, as you can see, that time drug price in India were very high in the year 1970. So to control those things, to save more and more people, we started following this type of a policy. Although the law permitted process patented related to medicines, they were very limited in scope. As I said, very few type of medicine basically are patentable. For example, if someone talks about eye surgery, where we can remove numbers. So for that reason, it is not something which a person don't go for this type of a treatment, then person not going to die, right? So if you have enough money, then only you can go and get operated and decrease your numbers. So this is one thing. So if I have enough money, then only I'll go for such type of a operation which charge like 50,000 to 1 lakh rupees. Now why government is not interfering in such thing, and why government is providing patent over such thing? Because this is not some necessity. This is not going to hamper, or this is not going to take someone's life. With numbers also people can survive throughout their life. So but with cancer or with some life threatening disease, people cannot survive. So for such type of medicine only we do not provide patent, but for other types of medicines we do provide patents. So if some talks about some plastic surgery or lip surgery, nose surgery, or some different types of surgery, and some invention happen on those type of a field, then we do provide patent over those type of a things. So as you can see, there is very limited scope on the same. So all the medicines are not patentable, few are patentable, few are not. The law thus created significant space for the entry of local pharmaceutical firms, and they started producing active pharmaceutical ingredients from the year 1970. Then Indian company became skilled in reverse engineering. Now this is very important point. Reverse engineering means just purchase some medicine from market, study their formula, and create or create a pirated copy of the same, in short. So that is what we mean by reverse engineering. Purchase a finished good and try to experiment on the same, try to study the same, how they basically manufacture that product, and will produce the same or copy of that type of a product. That is what we mean by reverse engineering. So many time Indian government also follows the same strategy, where we create generic medicines. Remember, generic medicines, that means medicines provided by government. So many companies are present in today's time in India, which basically manufactures medicines, as I said, for many life threatening diseases. But the cost for those medicines runs in like thousands and lakhs of rupees. And a person who earns 10 to 20,000 per month, he can how can he afford 50 or 1 lakh rupees medicine? So hence a reason government started manufacturing generic medicines. You must have heard about Amrut medicals. If you don't know, just google it. Those type of a medical provides generic medicines. So if some medicine cost you like 10,000 to 20,000, the same uh, generic version of the same medicine uh, might be available in those Amrut medical, and you might get the same medicine for 2 to 3,000 approx that the approx at that price. So that is the main thing. In 1995, India joined the WTO and TRIPS agreement. Trade altered the terrain of international IP law. But still, there are many companies who are not ready to come to India just because of this reason. But we still follow the same strategy, because we cannot, for their benefit or for our countries to stabilize our country, or for some economic benefits, we cannot avoid losing life of many thousands and lakhs of people because of some life threatening disease. And hence we follow this type of a pattern in today's time as well. Trips had more than, we have many agreements here. As you can see, we call it treaties. So we have signed many treaties as well, and in WIPO also we have signed treaties. Now, what do you mean by WIPO? WIPO stands for World Intellectual Property Organization. Now, as you can see, WIPO administered treaty, as treaties administered through the WIPO had no effective enforcement mechanism. So basically, previously, before WTO, there is also one organization which look after intellectual properties, and that organization is called as WIPO. But rules and regulation which is made under WIPO were not so strict that country should follow it. So many time country takes it voluntary, they don't take it seriously, in short. The same way, like right now we have uh, the same condition of United Nations as well. No one takes United Nations seriously. The same way, in that time no one used to take WIPO seriously. And to make some strict mechanism, international bodies came up with a solution or an idea which is named as WTO. Remember this point. The ministerial conference agreed that the TRIP agreement should not prevent member from taking measure to protect public health. So as you can see, to save the people, we can break some laws, or you can say we can compromise on some terms and condition which is present in this agreement. WTO member were under obligation to implement TRIPS provision by 2000, 2005 or 2016 depending on their level of development. So as you can see, in India, most of intellectual property related rules are amended after 1995. For example, Indian Patent Act was made in 1970, then amended in 1999. The same way Trademark Act also amended in the year 1999. Same way we have also created a new act, that is for ICs. So ICs, Integrated Circuit Layout Design Act, in the year 2000. The same way we also came up with a new rule called as Information Technology Act 2000. So as you can see, after 1995 we have amended or we created many different rules. Why? Because we are under the obligations of WTO, some international rules and regulations, and same should be applicable in India as well. Next is, India was given an extended period of time to make its patent regime compliant to TRIPS. Why we got some extra time? Because we are developing country. So most of developing country got extra time. Why? Because we are economically not that stable that we can just apply all the rules and regulation just in fraction of some time. And hence, basically, international body given us a time of 10 years. Remember, some African country also got more time than us. Why? Because they are way back as compared to India. Then earlier India had allowed for manufacture of generic version of many drugs. Though this amendment, IT has not implemented a product patent regime and product patent in a pharmaceutical sector. So we are still developing generic versions of many medicines, and in future also we are going to develop the same thing. I hope this particular point is clear. Now we'll just look at some of the amendment which is made in the year 2005. What are those amendment? Invention in step means a feature of an invention that involves technical advancement as compared to existing knowledge or having economic significance. So what we mean by inventive steps means in the existing idea we are making some changes. That is what we mean by invention. I hope this particular point is clear, and we already discussed in the part of patent as well, which is called as pt patent, extension of existing idea. Next is pharmaceutical substance, means any new entity involve one or more innovative steps, which comes under section 3D, has been amended to read the mere discovery of new form of known substance which does not result in enhancement of known efficacy of that substance, or mere discovery of any new property or new use for a known substance, or mere use of known process, machine or apparatus, unless such known process results in a new product or employs one new reactant. So under section 3D, if we have invent or made some changes in existing idea, but that changes is not that big, it is very small change, then we cannot apply for patent. And if only if we have made some exorbitant changes, then only we can apply for patent or extension of existing idea, that is pt patent. I hope this particular point is clear. In next lecture we will start discussing with this particular part, what are the defenses available in case of infringement of patent. Thank you.